Let me just get your overall reaction to the bombshells that were handed down by the High Court this morning.
Yeah, first, thank you for having me. It's really a pleasure to be here. I think the first thing the American people should take away, and hopefully the book demonstrates this, is that the majority in both cases is trying their best to get back to the meanings of the law and the original meaning of the Constitution. And they're spending a lot of time talking about that. I haven't had a chance to fully digest the opinions, but I think it just proves the thesis in my mind of The People's Justice, the book.
Because Clarence Thomas, who you zero in on, is fighting with the majority in all of these cases. Yesterday's case striking down affirmative action in college admissions process, today's ruling against Biden on his executive overreach with student loans, and critically, this free speech case. I have to tell you, and we'll get to more of the book in a minute, but I have to tell you, for me as a lawyer, it made my heart sing to see an opinion like this so strongly reminding the American people of the power of the First Amendment and chastising states who, in the name of equity, wokeness, however you want to phrase it, try to trample on those rights.
Yeah, and one of the important things, Megyn, not to forget is what the originalists are doing. They're not, and textualists, they're not stating their opinion. They're honoring the American people's opinion. And so when you point to the First Amendment, for example, it's the American people that decided that the First Amendment was the critical foundation in our rights, so much so that they enshrined it as the first in the Bill of Rights, in the Constitution. In fact, the Anti-Federalists fought tooth and nail for a right of conscience. And it was spelled out in more detail by James Madison in the First Amendment. And the whole point of originalism and textualism is to honor the will of the people. And when you do that, you most often favor the little person. Because if the American people want to change it, the beauty of the court enforcing the Constitution as written is the American people, if they disagree, have a mechanism to change it, whether it be amendments or through laws. But here, when it's a Bill of Rights, a right they enshrined in the Constitution, as you point out, the court has an obligation to enforce those rights as they were understood at the founding.
The free speech principles that are at the bedrock of the foundation of this country have been getting eroded bit by bit, whether it's by state laws that go unchallenged or by laws like this that a lower court will uphold in the name of, well, we have a state law that protects, that's basically an anti-discrimination law in public accommodations, and we just don't think that the First Amendment really is going to trump that. But this court really put the lie to it today, saying that's not true, saying you can have anti-discrimination laws. In this case, it's in public accommodations, like it was a web design proprietor who would absolutely serve LGBTQ members. Absolutely. If you went in there and said, I'm going to launch, a realty company, she would have built your realty company for you, your website, despite your LGBTQ status. She didn't want to do same-sex websites for them. That was the place she drew the line. And she came on this show and said, I'm not only fighting for people like me who don't want to do that, I'm fighting for people on the other side, same-sex marriage proponents who don't want to accommodate somebody who wants to have them do a website opposing same-sex marriage and maybe bashing something that they believe in. So this win is a win for all of us. However, I have to say, I've been shocked at the amount of jurists who won't stand up for this principle. And I wonder how big you think this landmark decision is in shutting down this erosion of the free speech principles.
Yeah, so let me stand up for my colleagues just a little bit here, because I think it's important that all your listeners know that we are trying to do our best. And it's helpful when the Supreme Court does this and gives us clear guidance, because a lot of these we struggle through. The briefs, the arguments aren't raised, the right arguments aren't raised, and we're bound by the arguments that are raised. I truly think, for example, on my court, I've got a total of 15 active judges right now and a bunch of senior judges, and I see them struggle all the time with difficult issues. But I think every one of them is trying to get it right. We may approach it from different angles, but we're all trying to get it right. And it's really one of the great hallmarks of the court as an institution is that despite the kind of what you see on the outside, on the inside, we all get along really well. And we're like brothers and sisters that have disagreements, and we work really hard. And I think my circuit is emblematic of that.
Yes, I agree. It's one of the best circuits. It's definitely better than the Ninth Circuit and the Second Circuit, in my view. But let's talk a little bit about the opinion because, the court really gets into it and says the following. Because we had Lori on this program, Lori Smith, and she is this small town woman who launched her own business designing websites and said, this is where I'm going to draw the line. I'm not going to do the ones that promote same-sex marriages. And there was a local law in California saying she must, that she has no choice, and that she was also prohibited from even posting on her own website that she is opposed to same-sex marriages, would not even allow her to say how she felt, and then tried to compel her speech, right? So they silenced the speech in one lane and they compelled the speech, or tried to, in another lane. You will do the website. You will use your own words to support same-sex marriages. And this is what the court wrote. Colorado defended its law. They said, under Colorado's logic, the government may compel anyone who speaks for pay on a given topic to accept all commissions on that same topic, no matter the message, if that topic somehow implicates a customer's statutorily protected trait. Taken seriously, that principle would allow the government to force all manner of artists, speechwriters, and others whose services involve speech to speak what they do not believe on pain of penalty. The court's precedents recognize the First Amendment tolerates none of that. And then it goes on to say, look, to be sure, public accommodations laws play a vital role in protecting the civil rights of all Americans. But they say at the same time, this court has also long recognized that no public accommodations law is immune from the demands of the Constitution. In particular, this court has held public accommodation statutes can sweep too broadly when deployed to compel speech. So what they're saying is a local law, a state law that is meant to protect these communities, minority rights, cannot trump the Constitution's free speech protections. When it's the state versus the Constitution and the right to free speech, the Constitution is going to reign supreme.
Yeah, and I think the court's really been consistent of that. If you go all the way back to their Skokie case, for example, and the right to march and speech we might not want to hear, you'll remember, and this kind of goes to Virginia v. Black too, which is in the book. You'll remember that speech we may not like, others are entitled to say. And this goes, I think the important thing is really that this goes all the way back to the founding, where the Federalists and the Anti-Federalists were going to stop the Constitution from being ratified if we didn't have rights of conscience. It was so important to them that people be protected from being forced by any government to say what they didn't believe. I mean, it's one of the great hallmarks of our country. In fact, it's why people can protest our rulings and often do. It gives them the liberty, the American people, the liberty to take an unpopular voice. And in fact, if you think about it, those unpopular voices, sometimes they're unpopular 30 years ago, become more popular now because they're entitled to be voiced. And countries that don't allow people to have a right of conscience are the very countries where the separation of powers breaks down, or they're dictatorships or monarchies. And that just isn't the United States. And I really think the court has been consistent here, from the Skokie cases to these cases to Virginia v. Black and other cases.
Now that summer's here, it's time to get outside and enjoy your backyard. But does your backyard need a makeover? Start with the perfect centerpiece, a Michael Phelps Swim Spa by Master Spas. A Michael Phelps Swim Spa can transform your backyard into an oasis. The swim spa is an alternative to a pool with the therapy of a hot tub. Michael Phelps Swim Spas have a water current so you can swim, do aquatic exercises, and have fun with the kids. And because it is heated, you can choose your perfect water temperature and use it all year long in any climate. Michael Phelps Swim Spas by Master Spas come in a variety of sizes to complement almost any yard, even if it's a small backyard. And this is not a long, intimidating project. In fact, delivery and installation can take less than a day once your space is ready. Michael Phelps Swim Spas are 100% made in the USA by Master Spas, the world's largest swim spa manufacturer. You are going to love your Michael Phelps Swim Spa by Master Spas. Go to masterspas.com, put in the promo code MK to save $1,000 on a Michael Phelps Swim Spa or $500 on a Master Spas hot tub. That's masterspas.com, promo code MK. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.